Welcome back to Joy News Prime. Let's get to our stories now. Jean Mensa has filed a new processes in court seeking the leave of the court to reopen his case and then subpoena Jean Mensa to testify in a new 37-page document filed at the Supreme Court moments after the court overruled its objection against the decision of the EC chairperson not to testify. Jean Mensa says he believed Jean Mensa would be testifying under oath until she decided otherwise. Earlier, the Supreme Court, in a unanimous decision, upheld the application by the first and second respondents not to call any witnesses in the ongoing election petition hearing. The decision by the Apex Court follows oral arguments made by the lawyers for the Electoral Commission and President Akufo-Addo that their clients cannot be compelled to testify. After the petitioner closed his case in court, lawyers for the EC, to the surprise of many, announced that Madame Jean Mensa will not testify and that they also closing their case, prompting an objection from lawyers from Mr. Mahama. Kwekwa Sante will join us shortly for details on this new application filed in court. But first, here's what happened in court today.
The Supreme Court, in its ruling, framed the issue before it for determination as whether or not respondents can be compelled to give evidence. The court held that witness statements do not constitute evidence until the witness enters the box and takes the oath to indicate reliance on it. This is against the background that Mr. Chachuchikata had argued that by filing a witness statement, the EC chairperson had elected to give testimony. Moreover, the Supreme Court, in its unanimous ruling, averred that the positions in affidavits in opposition to interrogatories cannot make respondents compellable. The EC, in its affidavit in opposition to an earlier demand by the petitioner to serve interrogatories, stated that those questions could be asked during cross-examination.
The law is therefore settled that a party will not be compelled to enter the witness box and testify in support of his or her case. It is a risk parties who decline to give evidence take, knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. Counsel for the petitioner has strongly submitted to us that we should not apply the Society of Law's case to the peculiar facts of this petition because the first respondent, being a constitutional body with defined responsibilities, must be brought before this court to be cross-examined as a way of accounting to the people of this country for its stewardship. The Society of Law's case, like this petition, also deals with witnesses who have served witness statements and have decided not to give evidence to be cross-examined. We are mandated to state that our jurisdiction invoked in this election petition is a limited jurisdiction clearly circumscribed by law. We do not intend to extend our mandate beyond what the law requires of us in such petitions brought under Article 64, Clause 1, challenging the validity of the election of a president. Simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondent to enter the witness box to be cross-examined. Accordingly, we hereby overrule the objection raised by counsel for the petitioner against the decision of the respondents declining to adduce evidence in this petition.
According to the court, the petitioner's case should stand or fail based on the strength of his case and not the weakness of case of the respondents, if at all. So the Supreme Court is expected to sit again on the 18th of February 2021. This will be after all the parties involved in this election petition have filed their final written addresses. And these final written addresses is sort of the conclusion of the case for all the parties to present their thoughts to the court before the court sets a date to render judgment. But of course, the petitioner's lawyers, Mr. Chachuchikata and Tony Later, have served notice that they will be filing for a review of this case that the court just disposed of, and also that I will be filing an application to subpoena the chairperson of the Electoral Commission to answer some questions. They have been at pain to explain that they are not trying to shift the burden of proof onto the Electoral Commission, but they are saying that as the constitutionally mandated body to organize the election and the chairperson being the returning officer of the election, it is important that she takes the box to answer certain questions. And so when they file these new applications, the court will deal with them before 17th, when they are all supposed to file their written addresses before the court sets a date for judgment. Meanwhile, Marietta Brew Apiapon, a spokesperson for the petitioner, expressed surprise at the court's ruling, describing the arguments of the respondents as wishy-washy.
On Monday, you heard the superior compelling arguments by Mr. Chikata. And of course, you heard the wishy-washy, insipid arguments by the respondents. Nevertheless, the courts have ruled in favor of the respondents, saying that they do not agree with us, that even though this is the EC, a constitutional body, the same principles that are applicable to ordinary people should be applicable to the Electoral Commission, and therefore they were upholding their request not to mount the witness box.
But Kojo Ponkroma, a spokesman for the respondents, say if the petitioner is seeking accountability, then he must use other means other than the court.
The third point that the Supreme Court has made today, that it has heard all of these arguments about she holds a constitutional office, the EC is a constitutional creature, and therefore there must be accountability. You remember that even for us speaking to you last week, we said if you want accountability, let's all go to Parliament, whether it's Public Accounts Committee or a parliamentary inquiry or something. But when you come and you apply to the court under some specific rules, you don't fail to meet that standard and then resort to that general argument. The court has said something about it, and I think we need to take note of it.
Let's get on to Zoom and speak with Kweku Asante, my colleague who joins us now. Kweku, what time was this process filed in court, and what are the legal issues raised by the petitioner seeking to reopen his case?
Right, Aisha. So it's very interesting to note that the judgment of the court was rendered around 9:45 a.m. thereabout. By 9:50 a.m., the judgment of the court had been rendered. And as at 11:20 a.m., that is just less than 2 hours later, the petitioner had filed an application to the court to grant it leave to, as it were, amend, not necessarily amend, but reopen his case and be able to subpoena the Electoral Commission to come and answer questions. And among other things, the application that was filed in court today recounts all that has happened in court thus far, and also attaches some processes that have been filed and the rulings given. Mr. Mohammed's affidavit in opposition avers that since the chair is not willing, the chair of the Electoral Commission is not willing to avail herself, he is directing his counsel to use his subpoena powers to use CF47 to compel her to attend to court and answer some questions. So according to John Mohammed's lawyers, the main reason why they want to reopen the case is to subpoena the chairperson of the Electoral Commission, Madam Jean Mensa, and also that the subpoena documentation is ready. And so as soon as the court grants it leave to reopen this case, they will serve those subpoena documents on the Electoral Commission. The petitioner is also saying that it will be in the interest of justice and fairness, and for there to be a fair trial, for the court to allow him to reopen his case, because they are saying that a couple of things that happened in court took them by surprise, and so they could not, or they were unable to advance certain arguments and certain evidence in court. And so if the Electoral Commission is electing not to testify now, then they have to reopen their case and subpoena her as they use the court's power to compel witnesses to appear before it and answer questions. And so if they do that, we'll be expecting that Jean Mensa will, for instance, have to testify to what transpired between her and what has become a bone of contention between some of the witnesses who have already appeared before court. Roger Metelnunu, for instance, arguing and claiming that the Electoral Commissioner asked there to go and see the petitioner, John Dramani Mahama, and explain certain things to her. And in his absence, the Electoral Commissioner declared the results. And so all these questions are the averments in the affidavits in support of the application which have been lodged at the court today. And so the court is expected to hear this motion on Monday at 9 and decide on whether or not they will allow the petitioner reopen his case and subpoena the Electoral Commissioner.
That was my colleague Kweku Asante. So on Monday, the Supreme Court will be sitting on this matter. Kweku Asante will be on that beat, and we'll be hearing what the Supreme Court judges have to say on this. We'll take a break on Joy News Prime. We'll be back with more.